Brad, my cousin came up on an H-2B visa. I think it's 3 months that they gave to him, but he wanted to extend it. How could he go about doing it, and how much would it cost him?
His employer has to do it. He can't do it. So an H-2B visa is a temporary seasonal worker. So either the season's going further,
Yeah.
or he's going to find a new employer, or change his status to some other status. Maybe he wants to go to school or something else. But you just can't just randomly extend an H-2B.
Just decide.
Just decide you want to do it. Just do it with the employer.
Could you explain more about EB-3 unskilled workers in the Philippines? I'm interested in immigrating to the United States.
Unskilled workers in the Philippines right now, those who started on January 1st, 2017 are getting green cards. Unskilled workers are basically your household workers. So your nannies, your housekeepers, people who are coming to work in somebody's home generally is your unskilled worker category. It is not a long wait. It is, I don't know, maybe 2-year wait. And what you have to do is you have to find an employer in the United States who's willing to sponsor you as the nanny or housekeeper. They have to be able to run an ad in a newspaper for 2 consecutive Sundays looking for an American. They hopefully can't find one for your sake. And then they file what's called a perm application and show that they made a good faith effort to find an American worker, and they couldn't. That perm application gets approved. Once that perm application gets approved, it's a labor application. They file an I-140 visa petition. It has to be filed within 180 days of the approval of the perm. They have to be able to prove that they can afford to pay your salary after all their other expenses are paid. So for example, if the husband and wife or the mother and father earn a combined $50,000 in income, they would not be able to sponsor you because more than half of their total income would be going to paying your salary. So for household workers, you would think generally that the combined income between the husband and wife, especially if you're going to be sponsored as a nanny for a child and have a child under the age of 14, you would think that the combined income of the husband and wife should be above $150,000, $160,000 in order for them to be able to prove that after all their other expenses that they can afford to pay a nanny a salary.
Okay.
Once that's approved, you're on a visa waiting list just like anybody else, like a mother filing for a daughter or anything else. The visa waiting list from the Philippines is about 2 years, start to finish.
And her follow-up is that she's currently, even though she's Filipino, she's in the Middle East working in an airline industry. Would that qualify as an unskilled worker?
Well, a lot of times stewardesses feel that they are the nanny of the
flight.
Of the flight,
right?
But no, that would not be an unskilled worker. You're not going to find like Delta Airlines sponsoring you as a stewardess. That would be a separate type of visa.
Okay.
That would be a crewman's visa.
A crewman's visa.
Yes.
But you're not
stationed.
able.
But you're not stationed in the United States.
Right.
Of America.
I'm here now in America as a J1 visa for my internship program, which is only for 12 months.
Okay.
My question is it possible if I can get a working visa or a green card?
Well, you can't get a work visa. You can get a work visa. I mean, maybe you can change to. There's not going to be an H1B because there's none available. Maybe there's some other sort of visa that you may be eligible for. I don't know. In terms of applying for a green card, people who used to come on J visas used to be able to overstay because they had a DS in their on their I-94, so they didn't have a 10-year bar to return. Trump has changed that recently. Now the 10-year bar goes into effect for people who have duration of status. So overstaying, getting sponsored in a job, which was the general process, is really not an option anymore. I don't have the option for you off the top of my head, but I would suggest is have a consultation with us.
I have a friend that's a babysitter. Her boss filed for her in March 2008. She got up to the I-140, but still is waiting. Is there any hope for her? If so, how long would this take? And if nothing can be done with that case, is there any hope for another avenue somehow to get her?
Well, she got sponsored in a job. And I guess she got sponsored after April 30th, 2001, and I guess she's not 245I, and she's overstayed her time. So unless she has parents or a spouse here in the United States it's legal, she can't do a provisional waiver to go home and come back. So the answer to your question is, unless you have a parent or a spouse who's legal, resident or citizen, you have zero hope in getting through on that I-140. We would have to come up with another option.
If I came here and I overstay, I came here, I have a child and my baby is here, but I'm out of status right now. But can an employee file my application, immigration application for me?
Well, you want to be sponsored by your employer.
Yes.
You've overstayed your time on your visitor's visa. The only
Yes.
time an employer sponsorship would work if you overstayed your time on a visitor's visa would be if you're
Yes.
245I eligible, meaning that you or your parents had something filed before April 30th, 2001, so you can pay the penalty fee here in the United States without going home. Or if you have parents or a spouse here that's legal, and then you can do a provisional waiver and go home and come back without a 10-year bar. Otherwise, you're going to have a problem finishing up your case unless the laws were to change.
My question is, since I have overstayed for about 27 days, can I still adjust my status while in the U.S.?
Can adjust your status. There's something called Section 245K. What Section 245K says is that if you have a visa immediately available to you within 180 days of your overstay and you did not work illegally in the United States, you can adjust your status still. So you're from the Philippines, I assume? Am I guessing right? Okay. So you're from the Philippines. Let's look at what the priority dates are for July 2018 for nurses. So nurses would be either the third category or the second category. So the third category, they're up to January 1st, 2017. That means that people who started in the third category as your regular registered nurse in January 1st, 2017 are getting their green cards. We're in July of 2018. So in that scenario, you would not be able to, if you got sponsored as a general registered nurse, then you would have to go back to the Philippines and you would have to wait about a year and a half to get your green card to come back and work for the facility. Now, if on the other hand, you were to get sponsored in a higher level nursing position, an advanced practice nurse, a operating room nurse, a practice management nurse, something that would be an advanced practice nurse, then you can get into the second category. And I don't know whether you have the qualifications for it, then you would be able to adjust.
I am presently on a J1 visa that expires, the contract expires on the 30th of this month. I have applied for a U.S. waiver and got a job that is willing to file an H1B visa for me.
Right. Did you get the waiver approved?
The waiver has not yet been approved. So right now it's at the Department of State.
Yeah, you can't do it until the waiver's approved. So number one, you can't do it till the waiver's approved, and number two, there's no more H1B visas. So you would have to go home or find some other visa status to go into and then come back the following year on an H1B.
I have a friend here. He has a business. And is it okay if I invest some money in that business?
Yeah.
Will that affect my travel?
It doesn't affect your travel. I mean, you can invest. You can invest any money you want. You just can't come here to go work in the business or deal with the business. I mean, you can come for a business meeting, but that would be about it.
Oh, so if I even invest in that business, I wouldn't be able to get a green card or anything through that business?
Unless you're going to invest $1 million, and that $1 million is going to cause the hiring of 10 U.S. workers for 2 years.
Okay. So it wouldn't make any sense then to do it?
No.
In the effect that I would want to get a green card.
Well, no. I mean, you could maybe get some sort of e-visa, which is an investor visa. Where are you from, Jamaica?
I am from Jamaica. I have a business in Jamaica too, my husband and myself.
Okay, so you can do an L visa. There's intra-company transferee visas. So in other words, if you own more than 50% of a company in the United States and you own a company in Jamaica and you want to transfer an employee, you can transfer yourself as a manager or executive and then apply for a green card that way. So yes, there's ways to do it. It depends on the amount of investment and how you structure the deal.
Please talk about L1A Visa.
That's an intra-company transferee visa. You have to be working for a company outside the United States for at least 1 out of the last 3 years. and the company outside the United States has to own at least 50% of the company in the United States, and then you can transfer as an executive manager or supervisor to manage people.